Construction contracts. What are they and how do they operate? Construction contracts can take many forms. They can be bespoke terms and conditions of a business or standard form contracts such as JCT or NEC. In fact, they don't even have to be in written form. For a contract to be considered a construction contract, it needs to be an agreement in relationship to construction operations. This could be for carrying out of construction operations, arranging for the carrying out of construction operation by others, or providing labor for the carrying out of construction operations. So what are construction operations? Construction operations are defined in Section 105(1) of the Construction Act 1996. Some examples of construction operations include construction, alteration, repair, maintenance, extension, demolition or dismantling of buildings or structures forming or to form part of the land, whether permit or not. Construction, alteration, repair, maintenance, extension, demolition or dismantling of any works forming or to form part of the land, including walls, roadworks, power lines, aircraft runways, docks and harbors, railways, inland waterways, pipelines, reservoirs, water mains, wells, sewers, industrial plant and installation for purposes of land drainage, coastal protection or defense. Installation in any building or structure of fittings forming part of the land, including systems of heating, lighting, air conditioning, ventilation, power supply, drainage, sanitation, water supply or fire protection, or security or communications systems. Preparatory work such as site clearance, earth moving, excavation, tunneling and boring, laying of foundations, erection, maintenance or dismantling of scaffolding, site restoration, landscaping, and the provision of roadways and other access works. Painting or decorating the internal or external surfaces of any building or structure. Certain works are not considered to be construction operations, such as drilling for or extraction of oil or natural gas, or extraction of minerals, to name a few. Why do I need to know if my contract is a construction contract? If you have a construction contract as defined above, you will have statutory rights to refer a dispute relating to such contracts to adjudication. An adjudication is a formal process of resolving a dispute, usually within 28 days, and therefore it is often preferred and more cost-effective than engaging in protracted litigation. Having a construction contract also means that statutory payment terms will apply to contracts where the payment provisions agreed by the parties do not comply with the Construction Act of 1996. It is also worth noting that pay-when-paid clauses in construction contracts are prohibited, and the contractors have a statutory right to suspend their works due to non-payment, provided that an appropriate notice is issued. Please seek advice before serving such notice, as failure to do it correctly could put you in a breach of contract. The above-mentioned implied terms do not apply to contracts with residential occupiers, and there is no automatic right to adjudicate a dispute. If you think you might have a construction contract and wish to understand more about the statutory rights and provisions that apply to those, please get in touch with one of our construction lawyers.